I hear you, but Mr. Hodges cannot speak with anyone but Mr. Stallworth.
Well, would it be better to push for the hearing so that I may speak with the judge?
I can't set any hearings with anyone but Mr. Stallworth. Mr. Stallworth is not here, then we proceed as if he is not here.
And
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just said I answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Welcome to today's Sovereign Double Feature, featuring two Moorish defendants who both owe quite a bit of money, but are convinced that legal responsibility doesn't apply to them. Our first case is presided over by Judge Andrews and features Mr. Stallworth, who owes a staggering $13,500 in unpaid rent to his landlord, but he's refusing to acknowledge that he's actually Mr. Stallworth, instead claiming to be an authorized representative, making a special appearance on Mr. Stallworth's behalf. Judge Andrews isn't buying this name game, but will it ultimately cause this SovCidiot to get evicted and hurt his pockets in the end? Stay tuned to find out. Our second case takes us to Judge Robinson's courtroom in Michigan, where we meet Marcus Campbell, who allegedly owes $18,000 to JP Morgan Chase. He's attempting the same authorized representative strategy, but Judge Robinson quickly shuts it down, prompting Campbell to reluctantly confirm his identity. He thinks he can avoid paying his debt simply by ignoring the bank's mail, but will that hold up in court?
All right, so are you Anthony Stallworth in position 7?
I am 8 Messiah Bay, the authorized representative on behalf of the defendant, Anthony Stallworth.
All right, so are you telling me Mr. Stallworth is not present here today?
I am. I'm telling you, I'm standing in as the authorized representative for him by special appearance.
All right, well, if Mr. Stallworth is not present here today, because he does need to be present to answer this calendar, then we'll have to move forward as if he is not here. Because Mr. Stallworth has to be present to be able to have any meaningful conversations with the attorney.
To have any meaningful conversations with who?
With the attorney. Mr. Stallworth is the only individual who can enter into any sort of agreement or negotiations with Mr. Hodges.
I see. Now, the communications that were between the defendant and the attorney through mail and court of record, is that not in the record?
Today, at this hearing today, Mr. Stallworth needs to be present to have a conversation with the attorney. If Mr. Stallworth isn't present, then we'll proceed without him.
Well, like I said before, my honor, I'm not here to argue the facts of the case. I'm just here. I'm the holder in due course. I'm representing the defendant as the authorized party to represent him during this matter.
I hear you, but Mr. Hodges cannot speak with anyone but Mr. Stallworth.
Well, would it be better to push for the hearing so that I may speak with the judge?
I can't set any hearings with anyone but Mr. Stallworth. Mr. Stallworth is not here, then we proceed as if he is not here.
And how do you proceed if he is not here?
I'm going to go ahead and make a motion to strike the answer, Your Honor.
All right, appearing Mr. Stallworth is not present, it being 2:07 p.m. Mr. Hodges.
Motion to strike
that.
the answer. Written stancher. And judgment for
Your Honor, I object.
that's a
It
lot.
is in the
You
court
can object
record.
unless you are Mr. Stallworth. I cannot have a conversation with you about this case, sir.
Oh,
Mr. Stallworth is the only person who has standing to discuss this case with the court.
And that's going to be Judgment for, gosh, it's a lot. $13,558.06.
All right, it being 2:08 is Mr. Stallworth. I'm sounding at this time for Mr. Anthony Stallworth. Mr. Stallworth. All right, there's no response from Mr. Stallworth.
Could you have him to repeat that number again? For me?
Therefore, your motion to strike is granted. A writ shall issue instanter and a money judgment in the amount of $13,558.06.
Thank you, Your Honor. I'm going to continue with my calls about those motions to seal.
All right, thank you.
We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
Name for the record is, I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand. So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay, so then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me. Okay.
Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock.
Thank you, Judge.
Thank you, gentlemen. We'll send out an order and let's be safe.
Thank you. You have a nice day, Judge.
All right. Thank you for coming in. We're off the record.
3 weeks later.
186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number.
82443.
And your name, sir?
Marcus Campbell and special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022. A series of responses, as it were filed, the last of which is a response to plaintiff's counter defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then he in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant has agreed that he owes the money.
Mr. Campbell, your response.
I disagree, and I'll stand on my brief.
And you stand on your pleadings. Okay.
Which was
All right. The court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court's register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. Mr. McCardle, do you have an order?
I do. I believe one was attached, Your Honor, to the. Should I submit another order? I was not aware that you had taken this case over for Judge Giles. Do you want me to submit an order with your name on it?
Actually, it really doesn't make a difference. It'll come to whoever issues the order.
Okay.
All right. Thank you both for coming in.
Thank you, Judge.
Be safe.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.